in terms of directors' duties, they're obviously more extensive than the codified duties that we've discussed this morning as set out in the Companies Act 2006. And the duties, of course, are enshrined in individual service agreements and contracts of employments, in addition to other areas of statute as well. But I think that the other point that I'd like to make is that it's important to look at duties in aggregate. The circumstances as such at the moment, and it was touched upon earlier, that it is very important for directors to be considering all duties. The acclaimed case in 2015 made perfectly clear that certain duties do not trump other duties, and I think that that's a very important point to make. They should be considered in aggregate as part of good corporate governance, I think, at this time.
So a clear message of a sort of balanced approach, taking all those 7 headlines together, which, if I can say, sounds like we're making the director's role doubly hard, but that is the reality, isn't it?
It is.
The government brought in this measure for the temporary relaxation of wrongful trading, and that is the only formal change that's come in so far. Wrongful trading, for viewers, is where the directors knew or ought to have known that the company couldn't avoid insolvent liquidation, and effectively any increase in liabilities of the company from when they knew or ought to have known, they could become personally liable for them. Now, in my opinion, this relaxation of wrongful trading doesn't really change anything for the directors. Wrongful trading was there to protect the directors and the creditors anyway. If the directors followed the rules, they had to take all reasonable steps when they knew they were effectively in that twilight zone, that kind of grey area. We're insolvent, will we survive, will we won't? If the directors follow the rules and take the advice that professional advisors can give them, they should be fine and they won't be on the hook. So I think it was more of a PR stunt from the government, and I get that, I appreciate that. But if directors follow the rules, they should be fine.
Think about directors and officer liability insurance. We've talked about the benefits of evidencing decisions taken by the board. There are opportunities in many cases to rectify issues if there are personal guarantees or security in place that can be looked at. It's worth doing those now because that can save problems later on. Being aware to the duty owed to creditors when the business goes into a difficult period is really key because it frames the way in which directors need to start thinking about what decisions they take and what they evidence. The aim with all this is really to make it clear that prevention is so much better than cure, and being aware of the risks really does help that. I would say take advice before injecting personal funds. We've heard about some of the powers that administrators and liquidators have, but so often I see directors who've put in emergency funds to try and prop the business up, who've then taken it out preferentially to other creditors without realizing that doing so puts them in a real problem situation. So I think assume the worst, prepare for it. That's not intended to be a negative sentiment. It's just practicality. If the business is presented with a statutory demand or a winding up petition, it's important not to ignore it because there's a limited window to deal with those and to mitigate those risks. And validating some of those payments if you've been presented with a winding up petition is always an option. So above all, I think take advice, use it, rely on it. It's a tool within your arsenal. That's not intended to be a pitch, but I think the likes of Andrew, Ryan and myself are are the sorts of people that you're going to want to be thinking about talking to. Your directors aren't expected to know everything, but part of being responsible as a director is working with professionals and third parties to help you shoulder that burden.
Evidence your decisions and put them on board minutes. Something that was touched on at the very start is illegal dividends. Directors should probably consider putting themselves onto PAYE and taking a salary rather than a dividend. That will protect them should the worst happen in the future. Fundamentally, look at your cash flows, create 13-week cash flows, best case scenario, perhaps medium and worst case scenario, and work on the worst case. Be prudent. Look at your pinch points and get your cash in as best as you can and seek the government help. That's what it's there for.